Shall be heard. God save the Commonwealth of Massachusetts. Court is now open. You may be seated.
Ferrari. Mr. McClay.
Madam Chief Justice, Associate Justices of the Supreme Judicial Court, good morning. May it please the Court. My name is John Paul Lecrae, and I'm here representing Mr. Leo Ferrari, who is here also, and who believes firmly that the indictment of dissemination of a matter harmful to a minor should have been dismissed in the Superior Court. He believes that because he had a trial on this, and in that trial the Commonwealth did not present sufficient evidence as to the third element of the indictment, and therefore he is presented at a second trial with double jeopardy.
Let me ask you a question, counsel.
Yes.
Is it your position that there had to be a concrete piece of evidence, a videotape that had to be shown to the jury in order to find your client guilty?
Yes, Your Honor, I do believe that. I believe that primarily because of the wording in the statute. As you know, the statute does define matter harmful to minor as matter that is harmful as obscene, or if taken as a whole. And then it cites the three elements, and it's on those terms that taken as a whole, which terms I could not find any case on that clearly define what it means.
You don't concede that there could be testimony that could depict the scene as a whole or the scenes as a whole sufficient to support a finding?
Well, I think there is case law that comes close to saying that. However, it did not happen in this case. The testimony that came out in this case did not go into the third element at all. And once again, there is no case law that clearly defines what is meant in the statute by that a matter must be taken as a whole.
So the rule would be, I just want to be clear on the rule, if we agree with you, is that they must produce the film, the videotape, whatever it might be, in order to convict someone.
Well, the rule is that they must present sufficient evidence as to each of the three elements in order to convict someone. How the Commonwealth may choose to do that, they should perhaps decide before they go to trial. If they have a tape or something that they can present to the jury, then they should do that. Whenever the material is tangible, whether it is a book, a videotape, or a photograph, then such matter must be presented to the jury.
So what you're saying is that you can commit this crime and throw the video out, and that's the end of the case.
No.
You can show these obscene pornographic materials to children and just throw it out and you're all set.
I don't think that the defendant is saying that specifically. The defendant is saying, well, you don't have sufficient evidence otherwise presented in the trial by the Commonwealth. You should present the tangible.
I take it that the complaining witness in this case testified as to what she saw on the film. Isn't that correct?
Yes, she testified as to what she saw, but her testimony goes directly to the first element of the dissemination charge, and also perhaps to the second.
What do you mean by the first element?
Okay, the first element is that the matter must describe or present nudity, sexual conduct, or sexual excitement so as to appeal predominantly, by the way, to the prurient interest of the minor. And okay. I think it's rather clear from the testimony that it does go to that element. And then the second one is the matter must be patently contrary to prevailing standards of adults in the county where the offense is committed as to suitable material for such minors. And on that one, I think that the Commonwealth also presented sufficient evidence to meet that one. However, the elements must be taken in the conjunctive. And on that point, there was a case that came down from the appeals court earlier this summer that was decided after the briefs were filed on this particular case, and I believe both parties submitted what I believe is called a 16-1 letter.
Yes,
and in that particular case, it goes really right to the same point. In that case, it's Commonwealth versus Militello. There were several boys who among other circumstances, were shown several photographs by the defendant.
Yeah, but those are photographs. What's the evidence in the record in this case that this 12 or 13-year-old girl saw the entire video?
There is no evidence that she saw the entire video, and okay. I think that is the problem with the Commonwealth.
Well, in fact, she was asked, what did you see, and she described what she saw. There was no further inquiry by anybody, I take it, as to whether or not she was shown any additional footage.
Well, there was certainly no further inquiry by the Commonwealth, especially as to the third element.
So the defendant could have showed her just excerpts from the video.
Well, then I suspect at that point the defendant would be put in the role of having to, it would be a role reversal. The defendant would have to then be going forward with the evidence, and I don't think that that would be appropriate.
But if she were only shown excerpts from the video, why would the entire video have to be produced? That's misleading as to the jury.
Well, the statute states that the matter must be taken as a whole.
But
suppose the complaining witness has not been shown the whole. I think that's what Justice Spina's question is getting to.
Well, we don't know that.
Someone may take something, fast forward to the sexier parts, show the minor those. The minor doesn't see any of the rest.
We don't know that she was shown the whole thing or not. We don't know if she sat through the whole thing or if she only saw certain excerpts of it. But we do know that it was a video, and it was in a video case. Therefore, it wasn't just small snippets that she was shown. She was shown a video. She described it as a video recording.
But I thought she was questioned. What else did you see? What else did you see?
She did.
She testified what else she saw.
And she just went on with the same litany of what these adults were apparently doing one to another in a sexual context as she described it. But she did not get to the third element of the...
But the third element being the whole?
No.
If she described everything she saw, why isn't that enough?
Because...
To meet the Commonwealth's burden.
Yes, it's the Commonwealth's burden.
Why isn't that enough?
Under due process concepts, that the Commonwealth must prove that there's a lacking of serious literary, artistic, or political content. And the Commonwealth did not present any of that in this particular case, where that does not come out in the testimony.
Well, but all she saw was people engaged in sexual or unnatural sexual activity.
Maybe that's all she saw. Maybe there was more things on the video that she saw but did not describe.
But we're talking about what's in evidence. And she was asked to testify as to what she saw. What else did you see? And she described what she saw.
And what she saw was not sufficient under the statute to prove the indictment as required under due process concepts and under the statute, because the statute say it must be taken as a whole.
Counsel,
we don't know what the whole is.
Let me ask you this. How is this case any different than the old case about the police officer who observed a dancer, and he testified describing what he saw? And didn't this court say that was sufficient, his description?
Yes, he did. The court did say that that was sufficient.
So how is that different?
The court described it in great detail, even describing the length. And that goes to that particular question, the length of each scene in the movie. We don't have a description of the length of the movie. We don't have a description of anything else other than what she claimed to have seen. We don't know if there was background music, if there was a plot, if there was some kind of a storyline. We really don't know what was on this tape, and it's the Commonwealth's duty to present sufficient evidence to prove what was on this video as a whole, and the Commonwealth did not do that.
So if it's undisputed in the evidence that a defendant, and it may not be this case, but if it were undisputed in the evidence that a defendant showed excerpts of a video that contained only sexual activity, and there was a storyline that had socially redeeming value and all those other things, and he didn't show that part of the tape, do you contend that the Commonwealth has a burden to show the entire tape?
Absolutely. If they have that tape, then they should show that tape because it is up to the jury.
Even if it wasn't seen by the minor?
Well, we don't know if it was seen or
no,
not.
I'm saying, if we know, in a hypothetical situation, if we know that a certain portion was not seen, the portion containing all the artistic material, if it were not shown, would that have to be presented to the jury?
Yes. And that's, again, I get back to the language in the statute that the matter must be taken as a whole.
Isn't it the whole of what was shown?
It's the whole of the matter from what I can see reading in the statute. Also, it states in the very first...
So a defendant could, or an accused, could take a video that has... a wonderful classical story, and there happens to be one sexual scene in there, and if the person shows just this sexual scene to a minor, it's okay because the story as a whole passes constitutional muster.
Well, and under those facts, if that was all that was shown to the jury, I'm not too sure. I mean, if that's what was all. But in this particular case, we don't know everything that was shown to the jury. In that hypothetical, I believe that still the language in the statute requires that the video be taken as a whole.
Well, we know what was presented to the jury. The jury heard the testimony of the person who saw the film, right?
Yes.
And she said, this is what I saw. What else did you see? This is what I saw. At that point, hasn't the Commonwealth met its burden? Isn't it up to you if you want to make some additional points, trying to either expand her memory that maybe she saw something else? Isn't that really your obligation at that point?
Well, I think that gets to burden shifting, and I don't think that it's appropriate for a defendant to have to prove or disprove a certain element of...
I guess what I'm suggesting is the Commonwealth has met its burden, and isn't it up to you if you have a defense here that actually there was a lot more to this, maybe the witness didn't understand, didn't see it, doesn't remember it? Isn't that sort of your burden to bring out?
No, and I don't agree that the Commonwealth has met its burden, because the Commonwealth must show even non-facts that relate to the particular case, and those non-facts would be the lacking of the serious literary, artistic, political, or scientific value as to minors. There is no evidence on that.
Mr. Lockley, may I ask you this question?
Yes.
And it goes directly to the appeals court's holding in Militello. To what extent is the jury permitted to take into account in making the determination on the third element what the defendant said to the children as they were witnessing whatever it was they were witnessing? So, to be specific, if I can take Justice Spina's question, let us assume that not only did the defendant pause the video at the precise moment, the child not having watched all the scenes, the pastoral scenes, paused the video at that point, invited the child in, then engaged in the kind of titillating conversation that the defendant appears to have engaged in Militello, inviting the child, would you like to engage in certain lascivious conduct with this particular woman, and then showing the video at that precise moment. To what extent can the jury take that into account in determining whether or not, although this is a piece of a literary masterwork, taken as a whole in those circumstances, it was in fact dissemination of matter harmful to a minor?
Well, I think the jury can take all of that into consideration, the context in which the alleged videos were allegedly shown to the victim. However, that also turns on what the jury may accept or may not accept as true from the witness. You may have one set of facts where it is claimed that it was a closed, dark room and they were by themselves. However, you might also have a situation whereas here, this alleged activity went on over the span of 2 summers. And the witness was there every single night from 6 till 10. And says she felt very uncomfortable. Nonetheless, she still kept going back. And if these...
how old is this witness?
She was 12 when she first started on the job. She was 13 when she left the job. And that was in August of 2002. So I think, yes, if you're going to take into consideration the context in which the videos were allegedly shown, then the jury can look at the overall context in the overall case, which I believe they did in this case. And apparently they did not believe much of the charge because, as you understand, in this case, the defendant was defending against 5 charges of indecent assault and battery on minors. And the jury found him not guilty on 4 of the 5, one of them having been found not guilty at a directed verdict by the judge. So the context does count, Your Honor, but it must be the overall context in the overall case, not just the context as given in one particular alleged showing of the videotape. And still, I still think, even under those circumstances, the Commonwealth must go forward and prove the third element of the charge if they wish to have a verdict of guilty sustained upon appeal. And let us not forget, too, that case law does hold that the appellate court, the viewing court, must view the matter as a whole to make determinations whether or not the First Amendment rights of the defendant have been abrogated.
Would you articulate that third element that you've been referencing? What is this third element that you say the Commonwealth has not proved?
Yes, it's in Section 31, third element, as part of the definition of the matter. It is 1 and 2, then it says and 3, and Militello said that you must take them in the conjunctive, that the matter lacks serious literary, artistic, political, or scientific value for minors. And
So you're following Justice Stewart's old axiom, I know it when I see it, and the jury's got to see it.
yes, to be absolutely precise, yes, and I think the statute's wording does say that if you're going to claim that it is obscene or it is matter harmful to minors, you have to judge it as a whole. And unless there is a very detailed description of what the video was, then I don't see how the jury can make that determination as a whole. And also, in the first element, it says that it describes, represents nudity, sexual conduct, sexual excitement, so as to appeal predominantly. There's, once again, a suggestion that there's a balancing going to be taken into consideration by the fact finder what is predominantly on the alleged video. And they can only do that if there is a very, very detailed description or if they get to see the video itself. And where there is no detailed description, then in those circumstances, it is the Commonwealth must present the videotape. I can see I'm running out of time. If there are no further questions, then let me say in closing, if you take all of the issues and you'll see them as you go through them, you will find in the final analysis that the record shows that the Commonwealth did not present any evidence, zero evidence, add to the third element. And therefore, if the defendant has to face these charges, again, we get into the issue of double jeopardy because there is insufficient evidence as laid out in Berry versus Commonwealth. That being the case, the defendant urges that this court must find that the indictment of dissemination of matter harmful to a minor should be dismissed. Thank you very much.
Thank you, Mr. Lafray. Ms. Glant?
Good morning. May it please the Court. Special Assistant District Attorney Cheryl Grant for Middlesex, and with me is Kerry Ailman, Assistant DA, who's the trial prosecutor in this case. The Commonwealth would urge the Court to find that the Commonwealth did present sufficient evidence through the testimony of the alleged victim in this case for the Court to find that all three elements were met that defense counsel was referring to in terms of dissemination of matter harmful to a minor, and that here the prosecutor asked open-ended questions of the victim. She first asked what happened that night in terms of describing one of the videos, and she said, I saw pornography, and the prosecutor asked, and what do you mean by that? And then the alleged victim went on to describe one of the videos she saw. And in the other two instances, the prosecutor asked her to describe what she saw, and that in those instances that it is fair to infer that the victim was in fact describing the sum and substance of what she viewed, and that there's nothing in the record to suggest that there was more that was viewed by the victim. And I would submit that it's speculation on behalf of defense counsel to argue to the contrary, and that there were no questions asked of that. There was just nothing in the record to support that type of conclusion, and that therefore she is describing the sum and substance.
I take it, Ms. Glant, that again, looking at Militello, that the Commonwealth position here is that unlike Militello, there was a description of sexual conduct, as opposed to, I was shown a photograph of a naked woman.
Correct. In Militello, they were describing Playboy photos, whereas there was no description of any type of sexual conduct. Where here, in each instance, the victim described various forms of sexual intercourse between men and women, and women. In various forms, which was not present in Militello. And also in Militello, they described various pictures that they looked at, but it was also, in that instance, they were shown a whole magazine. Whereas here, the victim testified, this is what I saw. In Militello, you had an instance where they described various photos, and there was actually a whole magazine at issue in terms of counteracting defense counsel's argument that somehow there was more shown to the victim here.
I can't remember everything here, but did she describe the titles of these videos? Or
No, there was no description of...
she just described the scenes she saw?
Correct. She was asked what she saw, and she described
what would the
what she
situation
saw.
be if in fact it was a movie, legitimate movie that had played in the movie theaters throughout the country, rated, R or X, whatever the real bad rating is, or unrated. And he showed her, but, clearly not obscene and within the Supreme Court's definition. And he showed her just those parts that involved a lot of sexual activity. Would that be considered disseminating harmful matter to a minor?
I would argue that it would, and that with dissemination of matter, one of the main issues is dissemination. The issue is the conduct. What did that person disseminate? And here, if in your scenario, I'm assuming in your scenario, they didn't show the whole matter. They could excise portions of that and show
sure. All
that.
you need is your remote control to
He fast-forwarded.
show whatever part you want.
Correct. And I would submit that that is the matter, and that
How do
does
you
meet the
deal with
definition
the
of
third
matter.
element? Put it this way, take even Justice Glaney's hypothetical and to say, you know, that it is, I don't have the words in front of me, you know,
Taken as a whole.
the literally,
Matter lacks serious, literally,
Correct.
artistic, or scientific value.
I mean,
okay,
here's
so
a-
literally or artistic, and take, you know, some
Yeah,
of
here's a
those.
movie that's considered to have artistic value. It's
fact, it
playing
won the
throughout the
Oscar.
United States, but it's got an NCR rating, whatever the bad rating is.
Well, that's when the matter is
Because there's
actually
some
the whole
really
video.
bad scenes.
Well, that
allegedly.
assumes that the whole video was shown. The question is what is the matter at issue in that case? And if what they only showed was two scenes, and that's all that they showed, dissemination of the matter in that case is of
what is
those two
disseminated,
scenes.
yeah.
Correct. That is what I would argue, and that meets the definition of matter. And
Let me just place you on this. Let's assume that, in fact, he's showing her, you know, these scenes from, you know, some, you know, movie that has been very highly regarded and awarded. It happens to have explicit sexual scenes, which doesn't seem to me to be that rare these days. And, you know, but it's got great literary value. I mean, you know, you introduce, you know, there's a, you know, leading reviewer who says these are the most beautiful scenes of sexual intercourse ever filmed. I mean, does that just go by the board for the Commonwealth?
well, again, if you're showing the film, the whole film.
No. I'm maybe showing parts of the film, and she came in at that time, and I didn't switch it off, or whatever it is. But in other words, the Commonwealth's position seems to be that if it's if you're showing anything that involves sexual conduct, whether the whole movie is non-stop sexual conduct or only a piece of it is sexual conduct, you've satisfied your burden. The defendant seems to be showing us, no, you've got another element, and there may in fact be some sexual conduct, as I understand his argument, that in fact does have literally an artistic value.
Well,
Are you saying any sexual conduct shown to a minor can never have automatically satisfies the third
no,
prong?
I think you have to look at you have to look at it in context. You have to look at what was actually shown the minor. And in an instance where someone just walks in, you don't have the intent element
Right.
there. You
So
wouldn't have any purposeful
I'll help you.
conduct.
I will narrow it down to, he happened to show her only those parts of this highly regarded movie with great literary and artistic value that happened to have sexual conduct involved, and he showed her just the sexual conduct.
I would submit that that is the matter in your scenario. I don't submit that that's the scenario here because there's no evidence that this was part of some greater literary work in this case at all. But in that scenario, I would submit that the conduct is at issue, and then you have to look at what is the matter that's being disseminated. When you look at Commonwealth versus
So you
Raleigh-
would say if you are showing a minor only, in this case it's film, movies, of sexual conduct, and that's all you're showing her, that's all you have, that's all the Commonwealth has to do. I don't care whether this comes from, you know, some wonderful movie.
Well, because in this instance, you're looking at the First Amendment, in terms of the First Amendment concerns, you're looking at the First Amendment concerns of the defendant. And in that regard, you have to look at the speech of the defendant. And if he chooses to just show one scene, then that is his speech at issue, and then therefore that is the matter as a whole in that particular scenario.
No, that wasn't my question. My question went to whether or not you have to, if you are showing a minor only, I'm not talking about the defendant's First Amendment, but if you're showing the minor only pictures of active sexual conduct, that's all the Commonwealth has to show to satisfy the last prong. It can never have literally artistic value.
Well, there'd have to be a description of the scene, exactly what happened, and
I've
in
just
the whole
given that
matter
to
that
you.
was shown. You can't just describe one scene if the person was shown more than that.
No, she was only shown one scene.
Yeah, I would submit that that would be the matter, and that could be sufficient.
So the conclusion is, if you show a minor only sexual conduct material, I don't care where it comes from, that's sufficient.
I would argue that it could be, yes.
Well, a defendant, in those circumstances, a defendant, I take it, could show that portion of the video that was shown, and if it, in fact, that excerpt did have literary value,
But whose
it
burden
would
is
be
it?
apparent, wouldn't it?
Correct.
Whose burden is it?
It's
whose
the
burden?
Commonwealth's burden.
So if she's just describing it, all she's doing is describing it.
Yes, I would submit that based on, you have to look at the testimony. The court can certainly look at the testimony in any given case, as they can in this case, as was done in Commonwealth versus Kaczynski, Commonwealth versus Plank, which came to differing conclusions in those two cases. But that testimony can be sufficient, and that you have to look at everything in context. And certainly, if in any given case, they could describe it happened in a different type of context. You don't have any, here the Commonwealth presented testimony of the alleged victim in this case, and she said, I saw X, Y, Z, and this is what I saw when asked what she saw, and that from that it is reasonable to infer that is what she saw, and from that you conclude that there is no, from that the Commonwealth has shown that there is no literary or artistic value described in what the victim described in this case, and that the Commonwealth has met its burden.
And so the jury decides whether there's any literary or artistic or other value, correct?
Correct, as long as the Commonwealth has presented sufficient evidence under the Lattimore standard, then that can be reviewed on appeal in terms of looking at, well, was there sufficient evidence, much like is done in any case.
Does the Commonwealth frequently call expert witnesses on this subject, or is this usually just left to the jury's?
Sometimes they can be called, there's cases sort of on both sides of that issue. Are you talking about for all three prongs or for one?
Well, particularly the prong on which you need to show that it lacks serious literary, artistic, political, or scientific value for minors.
Well, really the only expert testimony, because the standard for that is whether a reasonable person would find literary or artistic value. The community standards portion that applies to the others doesn't apply to that. So really the only help of an expert might be, we've looked at this film in the collegiate environment or something to that effect.
Is matter harmful to a minor limited to sexual matter? Could it be other types of matter?
Well, under the definition,
It's nudity, sexual conduct, or
sexual
sexual
incitement.
incitement, so as to appeal predominantly to the prurient interests of minors.
correct. So
In your brief, you mentioned, I'm trying to remember this, so correct me if I'm wrong in my memory, but I seem to recall that there was a statement in your brief to the effect that you didn't show this, what was seized at the defendant's house. You did not show it to the minor because you thought it was inappropriate, given her age, to show it to her again. But what if the minor were 17 years old? Could you make the same claim?
Well, actually, in that case, the reason that it wasn't shown was that a video was found in the trailer of the defendant had a roommate, and it actually couldn't be verified whether or not that was one of the videotapes.
It wasn't because you didn't show it to her.
Well, I would
That's why
point
it
out that
couldn't be
the
verified.
statute doesn't actually have an exception to allow the prosecutor to show a minor the videotape, even unlike some of the other statutes, which
Like
sort of an
drugs,
issue. Correct. To even allow that, if technically you'd be
So I
violating the
guess the bottom
statute.
line is, it could be a legitimate movie, either on DVD or videotape. Everything's on DVD these days, but even though it is a legitimate movie, it could still be harmful to a minor if he or she was shown, usually a she, particular scenes that were fairly graphic.
It could, yes.
I mean, there's
Submit
some
that it
hot
Let me
stuff
try-
coming out of France
Sorry.
a lot. That's
I'm sorry, I didn't hear you.
There are movies coming out of France that would be banned in the United States, but are available in any video store.
Correct, and something may not be obscene, but it could be deemed harmful to a minor, because it has to be
Under
looked
the
at in
second
context.
test, under the second element?
Yeah, because in terms of, essentially it's obscene, but as to a minor, so you look at these issues, but is it appropriate for a minor or harmful to a minor, which may, obviously, if something's obscene, it's going to necessarily meet that definition.
Grant, maybe you could help me out, and if you possibly can, try not to think about the facts in this case. Think of your colleague prosecutors, okay, who've got different facts, and they're now reading this opinion. Would it be fair to conclude that if a minor testified, if we write this decision the way you want to, that if a minor testified that she had seen sexual conduct and then describes it, intercourse, between a man and a woman, or, certain kinds of touchings between, man and woman, woman and woman, that is sufficient to satisfy the third prong, that the Commonwealth is not required to produce any evidence that it lacked serious literary, artistic, political, or scientific value for minors.
Well, you'd have to be able to infer that that was the whole matter, and not that she was just describing one scene of a longer video. And in terms of when you look at the evidence, that a reasonable jury, it's a reasonable person's standard in terms of looking at that issue, whether something has serious literary, artistic value, and that a reasonable person can make that assessment.
Is that really
She's only shown adults engaged in sexual conduct. That's all she's shown.
If that's all she's shown, and the evidence supports that conclusion, I would submit that could be sufficient.
No, not could be, is sufficient.
Well, it would depend on the specific testimony at issue, but yes, it would be, if her testimony sufficiently described the matters and the other elements of matters harmful to a minor.
Can I go back?
Well, she's going to describe only nudity.
Only nudity would not be enough.
Why?
Because that's what cases have held, that there has to be some type of sexual conduct, just nudity alone, because it has to be appeal predominantly to the prurient interests of a minor.
But now you're
and
saying...
sort of like in the Rollins case, the court found that insufficient.
That's the first one. So now I'm saying just sexual conduct. Just sexual conduct. That's the first one. Nudity, you said no, because, we've got the recent Militello case and other cases. So now we're talking just sexual conduct. That's all she was shown. That's all she was shown.
That could be enough, as long as the testimony is sufficient to describe the matter, yes.
Or describe sexual conduct.
Yes.
So you don't have to and lacks in that case.
Well, I know my time's up, just to finish
Sure.
the question. Yes, under that the reasonable fact finder could infer from the testimony that the matter lacks serious artistic value, because if all the matter is sexual conduct toward a minor, that a reasonable fact finder could infer that there isn't a serious literary or political artistic value for minors. So I would say yes.
Thank you.
Are there any further questions, or if not, I'll rest on my brief. Thank you.